and very good afternoon to everyone. My name is Richard Stevens. I spent 40 years in practice. I now earn my crust providing training in commercial law subjects, as well as acting as an arbitrator and mediator, mostly in the context, but not exclusively, mostly in the area of technology-related disputes. Law Before Lunch, it's designed to be nugget-sized. I look at one case or perhaps one principle of drafting or practice, and I aim to do that in less than 20 minutes so that we can all be slightly informed, slightly entertained, I hope, and go on and do some better drafting coming out of it. So, without further ado, I will share my slides with you. And let's have a look. Great. And I called this one What's in a Word? And a lot of you emailed me about saying, isn't that a bit of a tease? And I suppose it is a bit of a tease. And what's in a word? It's a little word that I've noticed coming into the drafting of guarantees and indemnities. The points I'm making are equally applicable whether I'm talking about a guarantee or an indemnity. Exactly the same point applicable. What's in a word? It's a little word that's been creeping in and it threatens to derail your drafting. Okay, so let's take a look at it. Chat is disabled, but as a little test, why don't you pop on the Q&A what you think that word is that I'm going to be talking about today? What little word do you see in modern guarantees and modern indemnities? It's crept into the drafting. It threatens to do a lot of harm in case you are people answering already, which is great. And so just put in what you think the little word is that I'm going to be talking about today. And the lucky winner will win free, gratis, and for nothing, a copy of my amazing book, A Right Rollicking Romp through the modern case law relating to contractual indemnities. It'll tell you everything you need to know about the modern case law. It will tell you practice points, worked examples, etc., etc. You will be in a brilliant position to draft indemnities going forward, which is more than can be said for the person that drafted the next clause that I'm going to be looking at. Now, when you are looking at, keep the ideas going. I see lots of people have been answering already on the Q&A. Chat's disabled, so try and put that word on the Q&A, and we'll come back to that in a minute. In a few moments, I will be making the big reveal, and I will be talking about a few cases related to how that word, that little word, can be interpreted in different contexts. But when it comes to drafting guarantees, very often the lawyers tend to be corporate finance or banking lawyers, and so they know what they're talking about. Guarantees tend to be well drafted. Indemnities, it's a completely different ballgame. Lawyers engage in the practice of what I call piling up empty expressions. And I think the best example of that, best being used in the sense of worst, is this clause. Mr. Dunn, it's multiplex and Dunn, Mr. Dunn had been given shed loads of cash to prop up his failing construction company. He was asked to sign this document. I won't call it a guarantee, not yet anyway. Have a look at it. Let's see what the lawyer has done. Dunn irrevocably and unconditionally guarantees. Now, I interject at this point to say that that is brilliant wording, standard wording for a guarantee. That's absolutely fine. No objection to that at all. But what's the lawyer done next? Dunn warrants. Well, what on earth is he warranting? Is he warranting the quality of the paper that the guarantee is printed on? I mean, what is that warranty doing there? And then it goes on and undertakes. So what's the undertaking if it's not a guarantee? Now, remember, there's only one. I think at this point, the lawyer was having a bit of a laugh. Maybe they were having a game of cliche bingo because they were sort of trying legal cliche bingo, just bunging in as many sort of legal concepts as they could. Look at the next one. There's only one Mr. Dunn, but he's doing this jointly and severally. How can an individual do something jointly and severally? And then just to sort of add something to this toxic cocktail, in the following line, we've got this concept of immediate liability. And as we're just about to see, this concept of immediate liability is sort of rather inconsistent with the concept of guarantee. And I think at this point, the lawyers stepped back and thought, mission accomplished. I know, but what about putting in another word, another legal concept? And look what they've done. And as well as all of those things, Mr. Dunn will indemnify and hold harmless multiplex. So you have got a guarantee, a warranty, an undertaking, a completely redundant joint and several liability, a statement of immediate liability, and an indemnity. Six, half a dozen legal concepts in as many lines of text. I think the prize must go to the lawyer who did this. And of course, it had to go to the High Court. I think it was Justice Fraser who had to pick his way through this wording and basically answer the question, what on earth is this wording? What on earth does it mean? Anyway, it's time for the big reveal. That's right, the big reveal. I will reveal exactly what that word is, and I can also say that we have a winner as well, which I can also announce. So what is that little word? But first, a word from our sponsors. Only joking. No, only joking. I'm not going to give you anything from the sponsors. What is the little word? The little word is demand. And someone got it right. And you won't believe this. Do you know the winner out there? The winner is called Anonymous Attendee. As you will appreciate, I cannot send a book to Mr. or Mrs. Anonymous Attendee at address unknown. So I'm going to have to declare a spoilt ballot paper there and declare the competition void. I'm sorry about that, but someone did get it right. But lots of ideas from that limited, however, breach, save, due in due performance, harmless, defend, um, uh, uh, all sorts of things. But the word I want to talk about today is demand and how it can be abused and how it can derail your guarantee or your indemnity. As I say, it applies to both of them equally. First case came at the beginning of this year. Chugga Chug and Priv Invest. Chugga procured super yachts. Nobis Crude under contract to build a super yacht. Priv Invest was the holding company of Nobis Crude, and it entered into what I call the parent company guarantee. But what on earth was it? Let's have a look at the wording. I've broken it into two because the first few, not two lines, deal with if there is a contested breach. The second, if there is an uncontested breach. The second, if there is a contested breach. It's all one block of text, not the way I personally would do it, but there we are. If an alleged breach is uncontested by Nobis Group, this yacht builder, Priv Invest shall procure performance or pay as required. Now, I interject again at this point to say that is wonderful, perfect wording for a see-to-it guarantee, a contract of suretyship, as it is also known. That's the sort of wording you should be using. But what's the lawyer done next? On first demand being made by Chugga Chug. And it goes on. If the alleged breach is contested by Nobis Krug, the shipbuilder, Priv Invest shall procure performance or pay as required. Again, that's great wording if you're writing a guarantee, the sort of wording you should be using. But what's the lawyer done now? Against presentation of both A, an award, and B, a written demand stating that Nobis Krug is obliged to pay the amounts or perform the obligations. What on earth is it, and why is it important? Well, if it's an on-demand payment obligation, you make the demand in the stipulated manner, stipulated in the contract, and you cough up summary judgment, no questions asked, very easy. If it's a guarantee, then the person claiming it has to show an underlying breach by the underlying debtor before the guarantor becomes liable on the guarantee. In this case, the judge said, taking it all together, it was a classic see-to-it guarantee. So in other words, Nobis Group, this yacht builder, had actually to be in breach, and that was the trigger for the guarantor's liability, not presentation of documents. As if to show how common this wording has come along, within a few weeks of that decision, we had this one, CE Energy, I'll call them Energy, against Bashar. Energy was selling fuel to UOG, Bashar owned UOG, and he provided a, quote, guarantee, unquote, of its payment obligations. UOG didn't pay, so Energy wanted to enforce this, quote, guarantee, unquotes. But what on earth was it that he signed? Again, it starts well enough. Classic words of a guarantee. irrevocably and unconditionally guaranteed punctual performance of the payment obligations. Absolutely fine. No objection to that at all. Typical wording of a guarantee. But what's the lawyer done now? When UOG doesn't pay, Mr. Bashar shall immediately on demand pay that amount as if he were prompt principal obligor without any need whatsoever for energy have to obtain an award or judgment against UOG first. Those are the classic words of an on-demand payment obligation. If you looked elsewhere in the documents, I've given two examples here, the judge gave lots. Payment immediately on demand, payment of the demanded amount. This is how common, how prevalent this little word has become. So again, what is it? Is it a demand guarantee, in which case Mr. Bashar simply has to cough up as soon as the demand is made? Or is it a guarantee in the true sense, in which case Mr. Bashar can only pay up when there is proof of the underlying breach by UOG of non-payment? And again, the judge said in this case that taking everything together, he thought this was a see-to-it guarantee, a contract of suretyship. In other words, he would have to show breach first, and then Bashar would pay the sums due on the demand being made of him. But it was crucial to prove that the breach had actually taken place before it triggered Mr. Bashar's liability under the guarantee. But now it's train wreck time. We saw two cases where the guarantor, in a sense, got lucky. Let's have a look at what happens on the other side of the coin. Rubicon Vantage against Chris Energy. Rubicon was the owner of some floating thing or other, and this company with a long name, but it was abbreviated to KEGOT, was the charterer of this floating what's-it. KEGOT's parent company was Chris Energy. Okay, Rubicon, as owner, issued 4 invoices. KEGOT disputed all of them and refused to pay. So Rubicon proceeded against Chris Energy under the guarantee. Okay, let's take a look at it. What on earth is it? Now, this deals with where there are reason to dispute. As I've said, these invoices were disputed. But let's have a look. 3 lines, 3 uses of the word demand. Where the amounts demanded under the guarantee are not in dispute between KEGOT and Rubicon, Chris Energy shall be obliged to pay the amounts demanded within 48 hours from receipt of the demand. Okay, as I say, that doesn't apply because there was a dispute as to these 4 invoices. Well, in that case, we go to little a. Chris Energy shall be obliged to pay any amounts demanded up to a maximum amount of $3 million US on demand, notwithstanding any dispute between the counterparties to the charter party. There are lots of text cited by the judgment, but I put this one in. In no circumstances whatsoever shall Chris Energies, that's the holding company, the guarantor, shall their liability hereunder vis-a-vis Rubicon, the owner, be greater than that of KEGOT, the charterer, vis-a-vis Rubicon under the charter. Chris Energy shall have all the limitations, rights and defences of KEGOT under the charter. Those are the classic words you put in a guarantee, and they indicate the principle of coextensiveness. In other words, the guarantor's liability is coextensive with the liability of the underlying debtor. So if I guarantee your debt for £1 million, for example, let's say I do it jointly and severally, only joking, I guarantee your debt of £1 million. If you don't pay, I'm in it for £1 million because my liability is coextensive with yours. I'm a guarantor. On the other hand, if you pay off half that sum, my liability as guarantor is for the balance of £500,000. My liability is coextensive with yours. But what have we got here? What on earth is it? As the judge said, there are elements here of both an on-demand bond and a see-to-it guarantee. Now, as I always say, the only person that would enter into an on-demand bond is either a bank or an idiot. Now, that's not to say that banks are idiots. On-demand bonds underpin huge international infrastructure projects. They are a crucial part of modern trade and domestic trade as well, normally issued by banks or insurance companies or investment companies. But of course, they're not idiots because they get paid for doing this, and they actually take security to cover themselves against the risk of the demand being made on them. That's one thing. Businesses, commercial organizations typically will enter into see to it guarantees, like a parent company guarantee, for example, a very typical example of a guarantee in the commercial setting. But as the judge said, and this is the modern approach to it, he said, look, there's no presumption here just because Chris Energy, a holding company, is a business and not a bank. I'm not going to stretch a point and construe this as a guarantee when the wording is clear on its face. This was, said the judge, a pay now, argue later type of arrangement. It was an equivalent to an on-demand bond. Chris Energy, as the holding company under this capital G guarantee, had to cough up 3 million US until the dispute was resolved. So it was more like an on-demand bond, a security against the dispute being resolved. So what can we learn from all of this? Guarantees tend to be well drafted. Indemnities, not so. You see people like that lawyer in the Dunn and Multiplex case. They just pile up empty expressions, as I call it, and you'll typically see wording like this: save and hold harmless, indemnify, keep indemnify, indemnify and hold indemnify. If you want to find out what these terms mean, you can have a look at my book. But if you're the one giving a guarantee or an indemnity, it doesn't matter. It doesn't matter either. This advice is applicable to either. If you see the word demand in there, an alarm bell should go off. And you should think to yourself, what am I entering into here? Is this really a guarantee or an indemnity? Or is this starting to look more like an on-demand bond? There's quite a good deal of litigation that's been going on about this for several years. And I see the word demand creeping into indemnities all the time. And it's a danger word. There are other similar expressions that you should also be aware of. Shall immediately be liable, shall immediately pay on demand, shall pay against presentation of a written demand, shall pay against presentation of the following documentation. These are the words typical of an on-demand bond. They're not the words typical of a guarantee or an indemnity. There's a deal of case law on it. If you see that sort of wording and you're the guarantor or the indemnifier, alarm bells should go off in your head. On the other hand, of course, if you're the recipient, the happy recipient of the money, hopefully, then demand immediate liability. These could be good words to put in there. Well, if you liked what you heard today, you can buy me a coffee, even better. You can ask me to quote for some commercial law training in your organization. Happy to take any questions, but that's what I was going to say today.